Hello, and welcome to Williams Mullen's Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host, Tom Bergert, and today I'll be joined by my colleague, Clint Brannon, a partner in our IP practice group here at Williams Mullen, to discuss Patent Office secrecy orders. Clint, how are you doing today?
I'm doing well, Tom. How are you doing?
Doing great. Glad to have you here and glad to talk about this topic with you. As a first question, why is the Patent Office involved in the issuance of secrecy orders?
That's a very good question, Tom. It really goes back to the beginning of the Cold War. And the various agencies in the United States at that time were very concerned that patenting activity might lead to sensitive technical information being published and made available to America's enemies. And so the Invention Secrecy Act was enacted at that time, and it sought to prevent publication of patent applications that were deemed detrimental to the national security of the United States.
Okay, so if I'm an applicant and I think my technology may be, but I'm not sure, do I need to put that on the application cover sheet, or how do applications wind up subject to secrecy orders?
That's a very good question, Tom. Generally, patents don't publish until 18 months after they're filed. And during that time period, interested agencies such as the Department of Defense or the Department of Energy may review patent applications and determine if any of them may be detrimental to the national security. The PTO can also review applications itself and send them to those agencies for review. And you will know within 6 months of filing your application if that has happened.
And so how, if I'm the applicant, how do I find out about that? They notify me, or how does that work?
Yes, the Patent Office will actually send out, much like it sends out any communication during the patent prosecution process. It'll send out a notification that your patent application has been subjected to a secrecy order.
At that time, do I freak out, or what do I do? Does it give me any kind of options or actions that I need to take?
Well, there are several different types of secrecy orders. There are 3 primary types. And the first one is a Type 1 secrecy order. These secrecy orders relate to critical technology with military or space applications, and they still allow you to undertake foreign filings in certain jurisdictions, and they still let you share your invention with U.S. persons. And those are U.S. Citizens, U.S. companies, organizations incorporated in the United States. So for those applications, there are some limited restrictions on what you can do. Type 2 secrecy orders relate to classified or classifiable information, and that information is treated just as if it were classified like any other DoD or DOE material. So that's much more restrictive. And lastly, Type 3 is most restrictive, and that basically means you cannot disclose any information to anyone without written permission from the Commissioner of Patents. So it essentially shuts down not only your patent application process, but any other activities you are undertaking with that invention.
So it sounds like I don't have to respond actively. It's more of a what am I limited in doing, and who can I disclose relevant information to? Is that accurate?
That's correct, Tom. Yes, you don't have to actively do anything in relation to the secrecy order.
Got it. So if my application is then subjected to a secrecy order, what happens to the application?
That's also a good question, Tom, because as a patent applicant, you've invested a lot of money and time in getting your patent application filed, and you would like to reap the benefits of those activities. The good news is that while it's subject to a secrecy order, the prosecution of the application continues. However, the application will not publish. If you continue through the prosecution process with office actions from the examiner, responses to those office actions, and actually get to the point where the patent application is allowable, that's where the secrecy order has an impact. And it essentially stalls the patent prosecution process at that point until the secrecy order issue is resolved.
And when is that resolved? Is there a standard time, or does it depend upon the application?
There is a standard 1-year limit for a secrecy order. However, they can be renewed for multiple 1-year terms, and it's very common for them to have 2 or 3 renewals.
And that process, is that the same type of notification? So I have a 1-year secrecy order, my application is still pending, I haven't heard anything. Do I get another notice that says it's been renewed, or how do I inquire about that?
Yes, you will get another notice stating that the secrecy order has been renewed for another 1-year term.
Great. Other than a secrecy order, is there any other way that an application that I file might not be published?
Yes, there may be instances where you as a patent applicant do not want your patent application published. Maybe you don't want your competitors to see what your R&D is currently doing. There may be other reasons related to investment and other concerns. And one of the things you can do is you can submit a non-publication request. Once the PTO receives that, they will withhold the application for publication. However, that comes at a cost. You will not be allowed to seek foreign counterparts of your U.S. patent. So you couldn't simultaneously seek patent protection in the United States and another jurisdiction.
Okay, so if I want to file abroad, I cannot request non-publication.
That's correct.
Okay. So back to the secrecy orders then. What are my rights if the USPTO issues a secrecy order?
You do have a few recourses if the Patent Office issues a secrecy order against you. One good thing is that I mentioned earlier that you have a delay in issuance once your patent application gets into a state where it's allowable. You do get a patent term extension in the amount of time of that delay. So what that means is if your patent application is delayed from issuance for 2 years, you will have the term of the patent extended through a patent term adjustment for a period of 2 years as well. So you get some of your time back, but it comes on the back end of the patent rather than on the front end of the patent. The other course of action you can take if the secrecy order issue persists for an extended period of time is that you can request compensation from the government for the damage caused by the secrecy order. And this is limited. It is not really intended to fully compensate you, but what it does is it at least mitigates the damage somewhat. The default rule is that you get 75% of just compensation as determined by the head of the agency that issued the secrecy order.
Interesting. So if I should violate a secrecy order, I know you talked about the Type 1, Type 2, and Type 3 secrecy orders. What happens? How do people know, and what happens to me?
Well, there can be some serious consequences for violating a Patent Office secrecy order. You're subject to fines of $10,000, and you're also subject to imprisonment for not more than 2 years.
That sounds like a key takeaway to me. What other key takeaways should we take from this episode?
Well, I think it's important, especially for companies who operate in the defense industry, to be aware of Patent Office secrecy orders and to recognize that this is something that may pop up from time to time. Don't panic. It's not the end of the world. There are some additional burdens imposed, but there are also some remedies that help mitigate those burdens somewhat.
Very, very helpful. Thanks, Clint. Well, that wraps up our discussion about Patent Office secrecy orders. I'd like to thank Clint Brannon for joining me on our Trending Now IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our IP practice webpage at williamsmullen.com/IP. And there you can find out more about our team as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thank you for listening, and until next time.